All right, let's dive right into this. Welcome to today's Explainer, where we're stepping directly into the high-stakes legal world of professional negligence. Think about it. We rely on experts every single day of our lives. We trust surgeons to operate on us, mechanics to fix our brakes, accountants to handle our taxes. But what actually happens when the people we trust with our lives, our livelihoods, and our freedom get it completely wrong? So it brings up a really fascinating question, right? How do we legally define the line between an unfortunate, unavoidable mistake and actionable malpractice? When an outcome is bad, is the professional automatically to blame? Today, we're going to unpack exactly how the legal system measures a professional's conduct. And as you'll see, the law's definition of a professional might just surprise you. Here's our roadmap for the case files today. 1. The elements of negligence. 2. Walski, proving the standard. 3. Hall, the national standard. 4. Lewis, defining a professional. And 5. A summary of professional liability. Section 1. The elements of negligence, the 5-part legal framework. To really wrap our heads around these cases, we first need our foundational framework. When a plaintiff sues for negligence, they can't just walk into a courtroom and say, "Hey, I got hurt, make them pay." They have to prove 5 distinct elements by a preponderance of the evidence. Think of this as your ultimate legal checklist. First, duty of care. Did the defendant owe the plaintiff a duty to conform to a specific standard of conduct? Second, breach of duty. Did the defendant's actions fall below that accepted standard? Third, actual cause. Was there a direct, literal, but-for connection between the conduct and the injury? Fourth, proximate cause. Was the resulting harm a foreseeable result of that breach? And fifth, damages. Did the plaintiff suffer actual harm or loss? Keep this checklist in the back of your mind as we go, especially the first two, duty and breach, because that is absolutely where the fiercest legal battles are fought when professionals are involved. Section 2. Walski v. Tasinga. Proving the standard. This first case drops us right into a high-tension operating room. Harriet Walski had a long history of thyroid problems. When she went in for a surgery with Dr. Marvin Tasinga, it was definitely not a routine procedure. Because of her previous surgeries and radioactive treatments, her thyroid gland was severely enlarged and surrounded by this massive scar tissue. The anatomical landmarks a surgeon normally uses, they were completely distorted. During the operation, Dr. Tasinga identified the nerve on the right side, but on the left side, the scarring was so bad he had to make a really tough judgment call. He decided it was actually safer to make a wide cut and just skirt the left nerve entirely to avoid crushing it. Unfortunately, post-surgery, Walski suffered permanent vocal cord paralysis. She sued for medical malpractice, claiming the doctor breached his duty of care. Now, what's really interesting about this is the pivotal testimony from the plaintiff's own expert witness, Dr. David M. Berger. You see, to prove a professional breached their duty, a plaintiff usually needs an expert to establish what the standard of care actually is. Dr. Berger testified that he felt the acceptable practice was to identify the nerve on all occasions. But under cross-examination, he admitted something huge. He couldn't speak for the broader medical community. He literally stated, "I can only speak on the basis of my own opinion as to what I consider a proper option." This was the turning point in the trial. And because of that admission, the court directed a verdict in favor of the defending doctor. Why? Well, because medicine isn't an exact science. It inherently allows for individual judgment within established procedures. Just because two equally skilled doctors disagree on a surgical approach, in this case exposing the nerve versus skirting it to avoid massive scar tissue, that disagreement does not equal negligence. A plaintiff must prove that a uniform standard of care exists in the medical community and that the doctor deviated from it. Showing that one expert simply prefers a different method, that's just not enough. Dr. Tasinga's exercise of individual judgment didn't breach a uniform standard, so he was not liable. Section 3. Hall v. Hilban, the national standard. For our second case, we're going to test the standard of care not during surgery, but in a tragic post-operative setting. Terry O. Hall underwent a successful surgery to treat a blocked intestine, and the surgery itself actually went well. But when she was moved to a private room, her husband watched in horror as she experienced 14 hours of progressively labored breathing and changing skin color. He desperately alerted the nurses, who repeatedly dismissed the signs as normal. Meanwhile, the surgeon, Dr. Hilban, had gone home for the weekend. He made no follow-up inquiries, and the hospital staff never updated him on Mrs. Hall's rapidly deteriorating condition. Tragically, she died the very next morning of respiratory failure. During the trial, the plaintiff brought in 2 highly qualified medical experts from Ohio to testify about the post-operative standard of care. But get this, The trial court completely excluded their testimony. Why? Because of this antiquated legal doctrine known as the locality rule. Under this old rule, care had to be judged strictly by local geographic customs and by doctors familiar with that specific local area. Because the experts were from Ohio, the court said they couldn't possibly testify about the standard of care down in Pascagoula, Mississippi. Without expert testimony, the plaintiff's case was just thrown out. But thankfully, the Supreme Court of Mississippi stepped in and looked at the modern reality of medicine. And this brilliantly illustrates why things had to change. The Mississippi Supreme Court dropped this incredible quote that completely abandoned the strict geographic limitations of the locality rule. They basically pointed out that medical education, training, and scientific principles has become nationalized. A pulse rate of 140 means the exact same thing in Cleveland, Ohio, as it does in Mississippi, right? The clinical danger signals of respiratory failure do not change just because you cross state lines. So the court mandated a shift to a competence-based national standard, stating that a physician's core scientific knowledge and diagnostic capability should be judged by a national standard of minimally competent physicians. However, the court did include a very practical exception here called the resources-based caveat. While the educational and diagnostic standard is national, the law recognizes that a rural doctor in a tiny county hospital just doesn't have the same tools as a doctor in a massive urban medical center. A rural doctor won't be faulted for failing to perform a CAT scan if that machine simply isn't available in their community. But the baseline expectation for their knowledge, their skill, and their judgment, that remains the same everywhere. Because of this ruling, those out-of-state experts were allowed to testify, and the case was sent back for a new trial. Section 4, Lewis v. Rodriguez, Defining a Professional. Our final case file pivots away from medicine entirely. Imagine being in an interrogation room. Herbert C. Lewis was a corrections officer facing some serious allegations of drug smuggling. His employer required him to take a polygraph examination administered by Abe Rodriguez. Now, according to Lewis, right before the test, Rodriguez became obnoxious, belligerent, yelled at him, and even used obscenities. Naturally, Lewis was incredibly angry and upset while hooked up to this machine. Rodriguez scored the test, concluded Lewis was being deceptive, and Lewis was immediately fired. Lewis sued Rodriguez, but a major legal question popped up. Should Rodriguez be judged by the standard of an average, reasonable person, or is a polygraph examiner actually a professional, subject to the stricter rules of professional malpractice? Let's move to and see how this builds our understanding of who exactly the law considers a professional. The court used 4 specific criteria. First, they asked, is the work predominantly intellectual and non-routine? Yes, every examinee is totally different. Does it require consistent exercise of discretion and judgment? Yes, the examiner has to decide if a subject is suitable, formulate unique questions, and interpret physiological graphs. Can the output be standardized? No way. Every test is unique. Finally, does it require specialized training and state licensure? Absolutely. Polygraphers attend specialized schools, do internships, and must be licensed by the state. Because polygraphy met all these criteria, the court ruled that the professional malpractice standard applied. This is a real game changer. It replaces the basic reasonably prudent person standard. When a trade requires acquired learning and specialized training, you aren't just judged as an average citizen making a mistake. Your duty of care is judged against the strict standards of your specific profession. This is absolutely crucial because it meant simple negligence wasn't enough to judge Rodriguez's hostile conduct. It also meant that expert testimony from other polygraphers was absolutely required for the jury to understand the complex scoring methods and procedures. So ultimately, the court affirmed that the polygrapher is in fact a professional. Because their work isn't just pushing a button on a machine, it requires individual judgment, advanced knowledge, and discretion. They are legally bound to a malpractice standard of care. This ruling is huge because it holds specialized technicians accountable to a much higher legal standard than everyday workers. Section 5. Summary of Professional Liability. Synthesizing the cases. Okay, let's synthesize everything we've learned and see how that 5-part framework applies across the board. So the crucial point is how the courts systematically apply the rules of duty and breach. Let's walk through this matrix. In Walski, was the surgeon liable for the vocal cord paralysis? No, because the plaintiff failed to prove that a uniform standard of care was breached. Differing expert opinions are just a matter of surgical judgment, not negligence. In Hall, did the surgeon's post-op failure to check on his patient survive for a jury to decide? Yes, because a competence-based national standard of care applies, meaning out-of-state experts could absolutely testify regarding the physiological danger signs he ignored. And finally, in Lewis, was the polygrapher liable? Yes, because the court deemed him a professional, and he breached his specialized professional duty by contaminating the test with his hostility. It always comes back to defining the duty and proving the breach. Which brings us to a final thought for you to carry forward. We just saw a polygraph examiner held to the exact same legal standard framework as a surgeon. As our economy relies more and more on specialized training, complex software, and intricate certifications, who else in your daily life will the law consider a professional tomorrow? Think about it. The people handling your personal data, managing your smart home, or maintaining your electric vehicle. The line between a simple mistake and professional malpractice is shifting every single day. Thanks for joining me on this explainer, and keep questioning the standards around you.